and do it. I know that we've got a couple of people who are also absent today, so glad to be here so we can make the time. We'll call this to order. The August 10, 2023 meeting of the Flathead Reservation Water Management Board. So volunteer for an opening prayer, please. Teresa, please,
Sure.
thank you.
Yes. I think we should bow our heads and take a moment to acknowledge the many blessings that the Lord has bestowed on all of us and our community. We ask for His mercy and grace and blessings for others who may be in need of a home, who may be hungry, who may be struggling with grief and loss. We ask that He bless all of us with open hearts and open minds as we do the important business that's before us today. And we ask this in the Lord's name. Amen.
Thank you, please. Dennis, please.
First, please.
Here.
Bruce McDonald,
Here.
Clayton Matt,
Here.
Kevin Pitt. Here. Shane Anderson is absent today, and so is Roger.
Okay, thank you. As usual, we announce the meeting minutes are on the DNRC and CSKP websites. Just a word of note, I don't have anything from the private on the website. We want to double check the private website to make sure that those minutes are there. I think they're a little bit behind. I did check the DNRC website today just to make it be up to date. So this is just for your.
Mr. Chairman, we quickly approach the spot where we will no longer need to have that arrangement. So that's something to talk about a little later today.
All right, any potential conflicts of interest for the agenda today? Hopefully we've all had a chance to take a look at that. So Georgia,
No conflicts.
Lisa,
No conflict.
Ken? Best of my knowledge, I don't have any. I looked at the agenda once. There is something for me. I will raise it at the time, but so far, adopt agenda. So any comments, questions, or concerns about the current agenda? If not, we'll take a motion to approve the agenda.
Mr. Chairman,
Yes.
I'll note that on the agenda, we have a few highlighted items that are minor shifts from the publicized agenda.
Is this one available then on?
No, sir, it's not.
Or maybe while we're in the meeting, maybe we can get that. So, yeah. Any other comments? Probably one major note is that today we're starting at 2. We were going to start at 1, but because of schedule, we shifted to 2. So appreciate everybody's patience with that. Thank you.
Mr. Chairman, we were able to get the invitation about the meeting start time change out and publicized fairly quickly. So that part was kind of.
Okay, thank you. Anybody ready to approve the agenda? Teresa?
Yes, Mr. Chairman, I would make a motion to approve the agenda for the August 10th meeting.
Motion by Teresa,
Second.
second by Georgia. All in favor, say aye.
Aye.
Any opposed? Hearing none, it's approved. Thank you. All right, public comment for items not on the agenda. So anybody in the audience, either in person or online, the early opportunity in our agenda is to make a public comment or anything not on the agenda, just to bring it to our attention.
If you have anyone online would like to make a public comment, raise your hand. You can allow to speak. Not seeing a public comment.
Hearing none, there'll be more opportunity for public comment as we move through the agenda. So we'll close that section. More public comment, board business. Approve meeting agenda minutes from July 13. meeting minutes of July 13, please. If there are any comments, please make them now, otherwise take the motion to approve. Motion by Ken to approve the July 13, 2023 meeting minutes. Second by Teresa, all fair to say aye.
Aye.
Okay, to approve onto the July 27. Minutes. Are these the minutes where I had a question on whether or not we took action on the phone compensation last meeting. So the question is whether we took action or if that was postponed.
Mr. Chairman, board members, we have not been keeping track of the specific sections of the personnel policy and anticipate that personnel policy will ultimately undergo a clean vote once its sections are approved. So apologies for that. The spot that we do keep track of that information is within the document itself. And I've been trying to color code each section with approval dates as we move through there. Based on our previous conversation, Mr. Chairman, we did go back and review the meeting minutes, and there was an approval for $30 per month for the cell phone stipend.
Okay, so when we do get to that section, we can decide when we have that discussion. So, July 27.
Could I
yes,
ask
yes,
a clarification? I'm not following the discussion because I thought we acted on that.
we did.
last time.
He just confirmed we did.
Right, but, and then are we reconsidering it or? I'm
Well,
not-
it's on the agenda, which is the reason I'm asking. I was asking earlier, and I did speak with Roger a couple days ago, and he thought we had taken action as well. So I guess when we get to that portion of the agenda, today's agenda, we can decide whether to continue having discussion in the report. Okay.
Thank you.
Okay. July 27 minutes.
Mr. Chair, I move
Yes.
that we accept the minutes from July 27th.
Georgia makes the motion to approve.
Second,
Second by Teresa. All in favor, say aye.
Aye.
Aye, it's approved. Thank you. Okay, hearings, orders, objections, appeals. FRWMB council, and we have council here today. Welcome. Good to see you in person. We have this spare the screen. You can be here. Thank you for being here. And floor is yours.
Awesome. Yeah, so thank you for having me. It's gonna be interesting if somebody does talk to see how loud I actually do sound from the other end. But essentially what I'm here for is to introduce some necessary documents that are needed for the Office of the Engineer process with evaluating applications, hearings, and then eventually how that would go to a potential appeal to the board. We will also discuss some possibilities with the board appeal process as well. But that would need to also be, I would request that there's some sort of meeting between us and the board to go through that in further detail after this meeting. So that should not be too strenuous of a topic at the end there. Essentially, we can just go through the documents I have. I mean, unless anybody else has questions for me to start.
If we have any questions, just for the record and for folks online, maybe introduce yourself.
Sure, yeah. So I'm Haley Franzen, board counsel. Usually I am on the other end here, but I am up here in Flathead today.
Thank you.
All right.
Hearing none, we will ask questions as we go.
Okay, so the first thing that's listed on here is to introduce this flow chart. And just to have a little precursor here, so these documents and this flow chart and such came from conversation between the engineer Ethan and your board counsel. Essentially to make the process for staff and for the engineer easier and more streamlined. So when they get to that point, they have something in front of them. They aren't having to create this on the fly. So that is what this is all about. So this first document, which I do apologize for the colors and such, if they aren't legible. If the words aren't legible, I am more than happy to change that. That is not a problem, so keep that in mind. What this document shows is essentially the entire process contained in the hearing examination statutory authority within the ordinance. So in the ordinance, you have from section 22104 all the way to 22110. Everything contained within those set of statutory sections is considered the hearing examination process. What that essentially means is when that office receives an application, right? So it could be for a new water right, it could be for a change in authorization. If they receive an application, they have to essentially go through this entire process. Now, they wouldn't necessarily go all the way down, depending on what their decisions are and such, but this is essentially the entire comprised process in a visual format. And this was devised to essentially help staff and the engineer with just going to here being, okay, I see where we're going. This is my process. They can get the forms ready and such, hopefully to streamline some things, especially while staff might be short in this office.
Sure, question. This is meant to simplify the understanding, but one first glance at this chart makes it look extremely complicated. So, is there a way to summarize in simple terms what this chart is saying, or will we do that as we go through the form?
So essentially what's going to come from this form or this chart too is going to be more of like a detailed checklist as well that has some temporal timelines as well, especially for staff and engineer. So, you know, if they have 30 days to respond back to something or 90 days to respond back to something, that will be on that more detailed, verbalized sheet that will accompany this. So that is in the works. I wanted to get this out here to introduce it to the board. Not only to show how complex this process really is, but to also just get it on the books and maybe have some discussion. I mean, if there's anything apparent that you're noticing on it, any comments, any feedback, this is a working document. So I just wanted to put that out there. The detailed, more checklist document will come after we have these initial conversations.
But for today's conversation, at the moment, would it be good to have you walk through this generally, or do we do that as we're going through the form?
I would say let's do it that way. Let's pair it with some of the forms, because then that way you're seeing, okay, here's the form that would go maybe here in this part of the process. And then take your time after this meeting to go through this flow chart, to familiarize yourself with the process, and then also just check with the ordinance as well.
Okay, and so, I'm assuming then, as you mentioned, Ethan, you have been involved in the staff have been involved, you're familiar with this?
I've read the ordinance. The flow chart is as new to me as it is to you. I did, well, I looked at it maybe 15 minutes. But I will, if you'll allow me, Haley, I will point out a couple of things about the flow chart, because we're thankful that it'll help us figure out where we need to be. But these little purple boxes here on the flow chart, the reason I'm bringing them up, you'll see there's a bunch of them. Those are all appeals to the board. And so a lot of this chain of this can oftentimes perpetuate down to a possible appeal to the board, at which point, so that's really trying to get you a little centric on understanding that this flow chart does also affect you.
Okay, given that they're color coded, you'll have a checklist coming, as long as we have this. Would a color coded key, would a key for this be helpful? Like a map key?
Sure, if
Right.
that's something that board members and office of the engineer would appreciate, I'm happy to do that.
Well, for example, you just said the purple one. So maybe the yellow ones mean something, what's in the ribbons, that's all, if, as
Yeah.
long as it is color coded.
It is.
So with permission, board members, since I'm assuming the staff has this and you have this, I would like to allow the staff to ask questions as we go through this today as well. If they have questions, that's unfair. Okay, all right.
Okay, so the first document I want, if we're gonna go through, kind of in tandem, then the first document I would like you to look at is entitled Recommended Decision. Okay, so for spatial awareness, this document correlates to this gray diamond in the center, that very large gray diamond. The reason why it's larger in size and it's centrally located is because this is a very important document for the Office of the Engineer. This is essentially similar to a preliminary determination to grant or to deny that you would see with DNRC in water rights. So that is essentially what this document is. You'll notice that on this document, there's, I highlighted it because obviously if there were, each application is going to be evaluated differently. And so you would have, the engineer would have the choice to choose between to grant, to deny, or to grant with conditions. And so those would need to be selected based on the application submitted. And then I just put in here some stuff, I guess some highlights and maybe some notes for staff and for Office of the Engineer to follow, just so that they're knowing what to put in each section. And then there's an analysis section, and that essentially, what that does is it goes through elements of the water right for evaluation in an application situation. So you'll see on there, there's adverse effect and findings of fact and conclusions of law. Those are legal terms. Essentially findings of fact is just where you're listing the facts that are applicable to that specific element. And then the conclusions of law are how those facts tie into your supervisory law, which is the ordinance and the compact.
If I may, and that could eventually include case law. Is that just?
It could, yes. Once this office starts pumping out applications and decisions, we can cite to those decisions, yes.
In the meantime, however, this process would be separate from case law already associated with the non-compact portion of the non-payment law you said.
Correct. It would be important to funnel all of these citations to the office and the board specifically, yes.
So in the big picture, while there's a lot of other case law out there, that would be mostly state or federal. Depending on the specific case we're dealing with, may or may, any of those precedent may or may not apply.
Yes, so we're trying to stick here with what is governing the office of the engineer in this process, which is the ordinance and the compact.
Application numbers, how do we do those?
Working on that too, it's a different discussion.
Yeah,
You have a finance. You have Montana and some state law that's directly, so that's just a question, how we can address that.
So you can reference it, it wouldn't be necessarily binding, it would be more persuasive, but it would be fine to cite to it. I think this office, and the board, if they so choose, could adopt a policy where it is only citations to what comes out of this office. But that's also a different discussion. So I guess right here too with this one, I mean, this is a big piece too that I know Ethan and I have had discussions on, this possessory interest. And it's especially with being located on a reservation as well. This is going to be a tricky factor, I think, for this office and the board, especially when it comes to jurisdiction as well. So just keep that in mind when looking at these forms and the ordinance as well. And then it concludes with essentially the main finding or conclusion. This would essentially just be a statement saying to grant the application, deny it, or grant it with conditions. And then you'll also notice that there is a notice provision on this document as well. Because this document is a binding decision of the board or of the office, excuse me, and so it does need to be noticed.
which means
The parties involved just need to have notice of this, so all parties involved, and then depending on if you look at the flow chart, too, I'll just like quickly bring this up. There are these yellow boxes kind of throughout in the lower tier. Those are all public notice situations. That means where it actually needs to be published in a local newspaper, and then also put on the website.
Yeah, question, Mr. Chairman.
Yes.
Depending on an opinion or a document with the recommended decision, do we ever find ourselves in the position, once it's published as public notice, where we might have we could have either state or tribal attorneys objecting to the language used in the recommended decision?
That could be a possibility. I mean, they're always free to object. There's certain criteria, and we'll get to the objection forms as well, that an objector would need to establish. So they can't just, object for the sense of objecting. There has to be some sort of criteria for them to do that. But yeah, that is possible.
It is possible.
as water users,
Correct.
right? Well, that would be to the extent that they're water users. I wouldn't imagine that either government would want to otherwise appear outside of the capacity of the water user, correct?
Correct, yes.
Could they object to the conclusions of law if they thought they were misstated by our office?
As a water user,
Do we ever have those types of statements before they're used in a recommended decision. Do we ever have those types of statements vetted in some form or review?
I'm not sure what statement you're talking about. Maybe you clarify.
I will generally be vetting the things that I'm gonna put in here with
Okay,
that lady down there at the end of the table. But in terms of cooperating, trying to get things vetted through state or tribal legal services, that would have to be through some other kind of MOU if we were gonna pursue that. Otherwise, they would really be somebody else's legal counsel, and it would be more likely to object to the decision itself on the grounds that whatever decision this office made was a decision that they, on behalf of themselves as water users, did not necessarily agree with.
okay.
I think that's it, but I'm happy to continue to discuss other options for language seeking and such.
How is that on board? You're betting this hearings and decision, the recommended decision.
So legal counsel will not be involved in the recommended decision. That,
They just said he were.
no, I believe he was talking about just like issues that might come up with the application itself, like the application file. We wouldn't be doing anything in terms of where the engineer will go with conclusions in the recommended decision. No, we will be fully involved with the appeal to the board in that situation as board counsel, but not involved in the actual evaluation or determination situations with the office of the engineer.
But I think that generally you can help me with language, just not on the decision.
With the application or the determination.
The language that I would use, like, not the determination, but whether or not the structure of language that we would use generally, not specific.
Yeah, I mean, in this process here,
Like
yes, what we're doing
providing
right
this
now.
draft right
Yes.
here.
Yep,
Uh,
this is fine to do right now preliminarily. When it comes to actually assessing a specific application and making that determination, we will not be involved.
You see, you had a motion.
No, I'm,
Very early on in our discussions, and this reminds me of some of that. Because it, in my mind, begins to raise the question about passing legal support of that. Our attorney or his attorney?
We are
That-
the
that
board's
gets to
hired
be-
counsel.
That gets to be,
Yeah.
people will ask, and
Mhm.
that's, gets to be what I think the question is. Looking for.
Yes, our position is that we are board's hired counsel. So we represent the board, and its decisions that it makes. Ethan and the Office of the Engineer as a stem of the board. We are able to help with these legal documents in drafting and providing those to the Office of the Engineer. When it comes to decision making, we are not involved in that process. The only time we are involved in an adjudicatory process is when it comes to the board for appeal.
When it comes to the appeal in that process, as the board makes decisions, then we're addressing the water users' issues. And if there is it's difficult to try to, really articulate what, how to think about this right now until we've been through this, but
Yeah.
it sort of makes one wonder how we get through that process when we are also board for the engineer.
Yes,
And it does make me wonder, whether or not we should repurpose legal counsel some days. What's trickier, getting a good, initial decision? You know, by having appropriate legal counsel at that phase, the recommended decision, or supporting the appeal? Or maybe we need to different lines to do that.
And that's a good point, so I'm not sure, you know, I think what I hear even talking about is to be able to make the best decision possible. It would seem to be helpful at times to be able to rely on recommendations of legal counsel at times as well. So if that's not clear or available to the opinion process, then we need to talk about how we do that. If that makes sense.
Yeah, we can have that discussion. I think I still want to maybe clarify or provide a little bit more color on this too. So this recommended decision is essentially a technical expertise document, right? So it comes from essentially an individual or staff who have technical expertise in assessing water rights. Now, while I deem myself to be a water attorney, it does not mean I have the technical expertise that staff or engineer would have. So that decision that comes from them would be more technical and not necessarily needing legal drafting or review. The drafting and review for legal can come right now, right? Where we're drafting this template for them to use, and they just use what's on the template. They plug in their expertise and their facts from the application, and that's how they make their determination. I caution not having legal counsel for the appeal process, the board, because that is more of an appellate adjudicatory role. And not all board members have been legal counsel or have been involved in legal processes. That is something that I would just like to caution, because that can go to another court, potentially state court, federal court, or tribal court.
Wow.
I know, I feel like I came and I'm just bringing horrible news.
No, absolutely not. We
This is
need to get through this.
I had noticed in here that you had me listed as the hearing examiner. And that's why I was curious to ask, why am I listed as the hearing examiner instead of the water?
You can be listed as the water engineer.
Okay.
You know, I think it was more so a placeholder to come up with some sort of designation for you in this process. Because you are examining these things, you are going to be involved, you are going to be the hearing examiner when it gets to a hearing. So that is your title. There is no title in the ordinance for something similar to that. So that's why we stuck with the same term, since it's used in DNRC. But we're more than happy to choose the title you would like to deem yourself.
Question, is the de facto hearing examiner under your chart? If it's denied, there's an appeal to the hearing examiner, no, an appeal to the engineer, which is Ethan. So,
This absolutely came up at our meeting where we prepared to get the organization, these documents together. It's spot on to bring that up. It was a tough spot for us to work through, specifically because there's a history of that not going well for DNRC, where they had the decision maker serve as the hearing examiner, and the court decided that was a bad choice and directed DNRC not to do that. Now, in our case, we simply don't have, unlike DNRC, where you could go to some other spot, we don't have a surplus of other hearing examiners at the engineer's office.
worth considering for future discussion. I think we're gonna have to, I think the legal support and how that works, making decisions and going through a hearing process, we want to make as clean as possible, so.
The one, I think, difference between the DNRC example that I just doom and gloomed you with and this office is that there is still an administrative. I'm gonna reach out. I think it's administrative. When somebody takes an appeal from the office of the, or decision from the office of the engineer and appeals it to the board, I still consider that to be an administrative appeal. And so DNRC goes straight from that hearing to the court. So we do have another administrative appeal body, which is this board. So it sounds good on paper, this.
Without getting too far ahead of ourselves, would it be worth thinking about whether or not we should have a separate hearing examiner?
That can be a discussion. Yeah, I mean, what Ethan was alluding to was from a conversation we had where we did discuss this and bandwidth of the office. And just not having enough technical experts who could sign your name on a document like this. Because that's important, right? You can't just have any staff member of the office of the engineer signing something like this.
Mr. Chief.
Yes.
So if Ethan is listed as the hearing examiner in the ordinance, is that correct? Yes, no,
No, it's not.
it's not.
No,
Okay, then
there
there,
actually is no term for that position. It's just water engineer. It's
Water engineer, but even if it's titled water engineer there, at that stage, that person is effectively the hearing examiner.
de facto. So,
That's the function performed.
so my question is, if we were to create an ancillary body to serve that role to insulate the two, does that substantiate a change to the ordinance? And can a change be made, or is this an amendment to? How,
Well, all good questions for legal. My initial assumption is that if it required a change to the ordinance, something that we don't do, but we certainly, among a list of maybe other things, would want to recommend to the state and to the tribe to consider. So they have to make that change if it's a change to the ordinance.
And I would add too, that you'll notice a lot of the purple boxes, right? So appeals with word. That's in that process essentially to give applicants another chance to appeal this. So because there is no,
Separate hearings examiner as opposed to engineer. So the engineer makes a decision, issues it out. There's an appeal, hearings examiner hears their own decision. Then there's an appeal to the board. So we become collectively then the de facto hearings examiners at that next level.
right,
Short of that, yeah.
hopefully that helps a little.
that does, thank you.
It helps us. That question is going to be, does it help the applicants? Is everyone, our applicants and their legal counsel going to be satisfied with that process? And then I think after us, then there would be an appeal to a court of competent jurisdiction, correct?
Yes, potentially.
I know we're getting probably
In the weeds.
touching on a lot of different
So
elements of
Haley,
this,
she had
but
an hour and she was like, this won't take an hour.
But this is a good start, yeah, okay. So we have the recommended decision form. Anything else on that form you want to bring to our attention today?
Not for me.
Okay, any other questions by the board?
No, but I'd like to compliment you. I like what you've done with this one.
Very good.
Thankfully, there are great templates already there and plug and chug. Okay, let's let's turn to the public notice of recommended decision form. Okay, so again, on your chart, you'll notice yellow boxes kind of throughout the lower portion of the chart. That's for public notice. So that is what this form is for. Public notice only happens in certain situations. That's why you won't see them all over the place after certain recommendations. Because generally it's going to be for a grant of an application, since that's actually, or it's going to be finalized. Like if it's granted, it's going in towards the final stages. And so it needs to be noticed to the public that this application is going to be granted. That opens it up. So if there's objections or no objections at that point, then there's other situations that could arise, but essentially that's where the public notice comes from.
Those are all the yellow boxes.
Correct. And so just to point out too, in the ordinance, this does need to be published in a newspaper, a local newspaper. And that can be of the board's choosing. And then it also does need to be placed on the website as well.
Excellent, and Mr. Chairman, board members, the work that we've done with the water rights database includes, and we've actually gotten through this hurdle already, which is determining standards of notice. And in the database, each of the regional offices that issues water rights has a standing list of people that they would mail a notice to, even though they may not be in a more specific affected area. Of course, the tribe's natural resources program wanted to be on that list, and they are. The tribe's legal department want to be on that list, and they are. There's some DNRC offices that are on that list, and some other just standard, like every time a notice goes out, we're going to send a mailing off to that. And then in addition to that, the way the database helps us on this public notice process is that it allows us to pick an area of people that might be potentially affected. And then we can grab those contacts right out of the database and we can include that as well. So sorry to sidetrack that, but it does directly play into a lot of this other work that we're doing. Yes.
I think we need to underscore how important that is. And I'm so pleased to hear that. I think given some of the rhetoric we've been hearing on the reservation in recent weeks, having I would call it an interested parties kind of list, right? The EPA uses that too. Communicating that to the public in whatever way, I think, given the general climate of misinformation that's out there, this kind of helps dispel that. There's nothing sneaky going on here, right?
Yes.
So that's good.
So I have a question. So you've got public notice on both types of granting the application, but you don't have public notice to kind of weigh down the process when you deny the application. I was just curious your thinking there.
So that's in the ordinance, with denial. So the only time that public notice is coming up is when there's either, like, so if you look down here at, we'll go to the decision to deny, recommend decision to deny. If it's denied by the office, there's essentially 3 tracks we can do. There's application withdrawn, which essentially they're just, withdrawing that. There's a closing order from the office, that application is done. There's another side of it where it's deemed denied because there's just nothing going on. There's no objections, nothing like that. And so closing letter, that's the same way. Or they can appeal to the engineer. And so once you get down there, and you have decisions that are being affirmed or granted, that's where public notice comes into play. When it's denied, it's essential, and there's no objections or anything like that, there is no requirement for public notice in that situation.
There's no requirement, but would it be a good idea? I'm asking, I'm not.
Yeah, and I would have to think about
Okay.
that,
I think the public notice is intended to provide public notice to people who might be affected by an actual use or
Yeah.
change of use. If it's denied, there's no use or change of use being
Sure.
created. So that would be my thought on it, but
yeah, and that's where I go as well, just because it's generally affecting the party whose application it is. It's not going to be affecting a neighbor or such. I mean, if, you know, a new water permit is denied, their neighbor's probably gonna be pretty happy about that.
I was thinking more along the lines of George's comments. It's just be really, we don't have to do it,
Sure, sure.
but is it something we could do?
Yeah, I think that'd be a bandwidth.
other than public notice, the decisions will be listed somewhere.
Yeah, I have a couple of things. Good conversation.
They are.
The decisions will all be listed on our website and those
There you
all
go.
get pinned down. Now, the public notice process, it comes with some strings attached to it because once public notice goes out, if you do not object at the public notice phase, you now, associated yourself from the exhaustion of administrative means to participate. And so there's kind of a requirement if you really wanted to object when public notice comes out to do it. When I was a young lad and I first started working for the department, they just issued that there was an application, and they did not let the public know whether they intended to grant or deny that. And so when you hear this language like preliminary determination to grant, which is what the DNRC is currently using, or hear recommendation, recommended decision to grant, that's because in the past, even though the department was going to certainly deny something, they still had to go through this public noticing process and receive all the objections and hear all the objections, even though the result was already known. So it was a whole bunch of people's effort put forward to object to potentially adversely affecting new use that really didn't have to happen.
So it will be in the database, and the database will be made public. So in fact, we are letting the public know that we denied it.
But a little further more on that, if you will. So that everything in the database is public. All the events would be available there, but this noticing of decisions will actually be in a specific list on our website that is highlights activities that are happening out of this office, which is perhaps a little more user friendly, as we can dump those in by date and basin. And that helps people to just be aware of things that are going on.
Thank you. That takes care of my concern.
Although, I'm assuming that after we get things going and it'll be a little smooth. Especially early on, I'm wondering if something were to come up and you hit like 40 days and you're not quite at. Is there an option or opportunity to extend that 45 days?
Sure, yeah, that, and I'll just give an example that's similar to this. Right, so in district court or tribal court, there's motions to extend a deadline. And that would just need to be filed by the party, so the applicant with the office of the engineer. So that is completely possible for an applicant to do. And it is the office's prerogative to accept or deny the extension.
Thank you.
In contrast, we cannot extend our timelines. So any of the timelines imposed on this office are fixed. We're not sure what happens if we miss one, because I don't think we have so far, but we might find out one day.
Well, it's a good question. If somebody applies, and the decision's not made in the timeframe, it's automatically approved. Is that correct?
Yes, it essentially confirms whatever recommended decision, yeah.
That it on that document? Okay. Thank you.
So since we're on the topic of objections, let's turn to the example objection to application form, and then the complementary example objection evaluation form. These two documents.
Notice of objection?
Yep.
Okay, sorry.
No, you're good.
And the objection validity form?
Yes,
Okay, thank you.
perfect.
Which would you like up first?
Let's do that one, yeah, the application, yeah. Okay, so. This is essentially the form that an objector to a recommended decision would use with the office. Obviously, this is draft, so we can change it to however this office would like it to look. This is the form that needs to be filed with this office within that 45-day time frame, unless there is a motion for extension of the deadline that has been approved by this office. But this is essentially what they need to do. It is pretty similar to the DNRC objection form, so kind of staying in line with some of our other forms that we have at the office. You will notice that on page 2, that is where, oh yeah, did you want us to talk about standing there?
Before we moved off of it, I think this group might be interested in hearing a little bit about standing.
Yeah, sure. So standing is always a tricky topic, and it's one that usually is challenged quite often. Not necessarily in this context, but just in the legal world. So essentially, what this little synopsis sentence is saying is that the objector to this application has to have some like reason that they are objecting to this application. It has to adversely affect their water rights. It can't just be some tangent objection. They don't like the person, you know, they've always wanted that property or something, you know, and so that's why they're objecting to it. There has to be a basis for this objection. And so that is a threshold issue. If an objector does not have standing, the office can deny this objection. Because that is a complete threshold issue. They have to have that to even go through with why they're objecting to it.
The standing has to be technically related to the water use specifically, or impacts of the water use specifically. So if someone wants to object to the ordinance and the compact through this process,
That they would not have standing to do that. That is not in the jurisdiction of the Office of the Engineer. That's a great question, though.
that'll come.
Yeah.
Thank you.
And then, yeah, we want to go to page 2. So here's the big main question that the staff and the Office of the Engineer will be evaluating on this objection form. So that's where this about like validity evaluation form comes into play. It's essentially just taking what's on the objection form and creating a little checkbox for the staff in the office to go through. And if there's certain things on there, let's say they've raised an objection to possessory interest and adverse effect. If the office determines that they don't meet the criteria for possessory interest, but they do for adverse effect, they can proceed with their objection on adverse effect, but not possessory interest.
will adverse effect require some technical evaluation on their part they have to provide, or can they just say, I'll be adversely affected?
So it would be a technical, and there is legal determinations of that too. That a lot of that is actually put into the recommended decision document. So if you go back to recommended decision document, there's a section on adverse effect, and it does list what the criteria would be per se to evaluate adverse effect from this office.
So that includes potentially either hydrologic or engineering analysis from.
It could. Essentially, they should be submitting this though, the objector has the burden to submit all of that information. So the office and the staff should not be doing any of that on their own. The only time that they would be doing any of that on their own would be an appeal to the board. When they're a party.
Yes, Jordan.
Can you define possessory interest as it would apply here on the reservation?
Oh, we were just talking about this, weren't we? So. I don't necessarily know, I don't have a great answer for what jurisdiction with possessory interest is on the reservation. I can't give you that clear-cut answer. Possessory interest in terms of the water rate though, is essentially that you have that, like you own that right to use the water.
Okay.
Or you have somebody who does own it, they give you consent to use that as well. So there's two pieces of it that are lined out in the ordinance. How that plays in with jurisdiction is going to be a question that we are going to probably see.
Be similar to property, I think. You have the title for the property. So the records created here are creating the title to the water right.
Certainly.
And possessory interest on property would mean you own it, but maybe you lease it to someone. That's a possessory interest on water. To the extent that it's allowed, it would be leasing this property and that water with it. I don't know that so water leasing is allowed in our ordinance, but something attached to ownership.
It's very helpful.
That's my understanding. Right?
That's great.
The question, Mr. Chair,
Yes.
for me comes in, if you think about tribal trust property and the title of the tribal trust property is held in trust for the beneficial use of the CSKT tribes and its members. Can a tribal member who shares in that beneficial use declare an adverse impact? I don't know.
I can only think that if I have a lease property, like a home site that has on a lease of a well, somebody next door drills a well, I have my possessory interest is that lease, you're affecting my well, I go prove that it affects it, that I should have a right to object to that. Surface water would be the same.
But I can see where this could get incredibly complex because there's
Absolutely.
some parcels that have 120 different owners, right? And
Yes,
There are,
do you need all 120 to object or just one? Anyway, I'm going down a rabbit trail.
but good point, that's.
well, but it's a probably a rabbit trail we need to think about eventually because people are going to be filing for water rights based on their quote possessory interest.
We already spent a lot of time on that rabbit trail.
And I think I'm guessing that especially in that particular case, we want to team up with maybe tribal attorneys to have a better understanding of how that should work.
Most definitely.
I mean,
They've
even
given us
though,
some direction on how they want to see things for applications coming in.
Yeah.
On trust and allotment.
within the trust, lands, and I suspect it will get additional direction on how they'd like to see objections handled, so, yeah.
I will say though, for the, scenario you were talking about where, you know, you have 120 people that might be affected, does it just have to be one and they're all involved, or does it have to be every single one? The objection form does have a statement on here, and this is very common with all of these at the very end. On objector's signature under 8, whoever's signing this document is who's involved. So if you have 50 people in that area that might be adversely affected, they would have to all object to be involved as it proceeds forward.
But it's not conditional on getting the signature of every partial owner to proceed.
No, I mean, if you personally are going to object to an application, then yep, you can go forward with that. You don't need anybody else's signature. If they want to be a party though, they would need to sign it.
Thank you.
Yep.
Sorry to ask that questions.
No,
Legal terms are. working
So,
bad.
That's why we're here.
yeah, this is what this is for.
In George's
Can you-
example, you have 120 parties. One party objects. Board's gonna have to make a decision and knows it's gonna impact the other 119. So the board might be in a situation of saying these are necessary parties and bring them in. I'm asking.
I think that the objection period is in place for a reason. I mean, this is like in just water court in general, when you're receiving objections in a basin. If you don't object to it, right, then that your time's lost. I mean, you know, there was that chance to object to it. It's been noticed that there was this decision to deny or grant with conditions as well. Those were publicly noticed, and so that is spelled out where you do have that objection period. And if you miss the vote, that's just how it goes. There is a process that's different in water court than here, and I just want to bring that to attention. In the water court objection proceedings, there's a final step. So there's objection, there's counter objection, which if you receive an objection, you can counter object to that objection. And then the final step is called the notice of intent to appear, or NOIA. That is not, they are not a party though. So they don't actually have rights in the case to present evidence or argument or such. They're there to essentially see how this case will play out, and how that application will be determined.
Yes, it's gonna get complicated. The example of multiple owners on a particular piece of property though, I think, you know, we could go back and always find exceptions, but typically those owners don't all, are not all active in actually utilizing the property. It's either one owner, one of the owners, or it's leased out. If it's leased out, typically then it's for agricultural purposes, maybe potentially somebody living there, but then whoever's using the water then becomes theoretically the person with the possessory interest. But that's also going to depend on how the water rights file.
One more comment.
Yes,
As complex as this is, again, what I'm really encouraged by, and I hope the general public can gain an understanding of this for the two that actually listen. There are so many redundancies in here for the public to be made aware that there is no shady dealings, there's nothing sneaky, there's no agenda. And while I may not today understand all of this process, democracy is very much center stage in this flow chart. And that's something I hope people can gain an understanding and appreciation of. And I think we need to keep stating that. Because I'm hearing a lot of other stuff and it's not true. So. thank you.
I personally tend to think about it like it's a technical and legal process that we follow defined by the ordinance, not a political process.
Not for- But the fact that it involves the public and there's so much
Absolutely.
transparency.
That's on our side. On their side, they can assume it's political all they want. We just have to stick to our guns and make, keep reminding them and keep following the law.
Well, I have one final question.
Yes.
On your checklist here, the last was water quality. Is that straight out of the ordinance?
It is. And that would need to be a discussion that, we have office and legal counsel in drafting these, and determining the, conclusions of law for that as well, in the draft document. Because that is an area where, I mean, if you think on like the state side, DNRC doesn't do that, DEQ does. At least in terms of water quality being adversely affected and such. I mean, there is a little bit of a water quality piece on DNRC's side. But unfortunately, in the ordinance, it's not necessarily spelled out what that means. So that would need to be a future conversation.
I have a question.
Yes.
So on that, thank you, Ken. I hadn't looked at that language closely. Where it says water quality issue. And then it refers to a local water quality district. Should that not specifically refer to the CSKT water quality standards? Because they have jurisdiction within the exterior boundaries of the reservation. In fact, they were the first tribe in the nation to get those. Secondly, when it refers to effluent limitations of a discharge permit holder on this reservation, NPDES permits are issued not through DEQ, but through the EPA. So should that not also be identified?
Yes, it should be corrected to that.
Okay. Because the difference would be that NPDES permits within the exterior boundaries of the reservation have to comply with the tribe's water quality standards, which in some cases can be more stringent than those of the state.
Potentially, I mean, with water quality, because we don't necessarily know what they're looking for in terms of evaluation from this office. There are, and because this board does have jurisdiction on both ends. There is that interplay of the state water qualities standards and the tribal water quality standards.
Oh, gotcha. Okay.
So that'll have to be a discussion and how we draft those conclusions of the law for that evaluation.
You'll remember that we had the Sanders County Sanitarium show up at one of our earlier meetings. And talk about how they have a permit process for drilling the well to make sure that it's situated appropriately. And so, well, different than the fluent kind of thematic that I was thinking of when I read this, but it's in there.
My question on the whole water quality question for us is what exactly will be our role in that? Because while there may be language in the ordinance that references or refers to water quality, this ordinance is not a water quality ordinance. So exactly what is our role in how we deal with that? I think that'll be important.
Yeah, I think that's where that conversation needs to happen. We can also look at what, how the DNRC looks at that in the water rights realm.
Yes.
Specifically, and just keep that as a minimal analysis, similar to how they do. Because you're right, this is not a water quality compact or water quality ordinance.
Yes, yes.
However, if people are drilling a well for groundwater, for domestic drinking water use, they do need to make sure that that water is safe for drinking water use,
Not through this ordinance,
not through the ordinance.
not through this ordinance.
I see what you're saying. Okay,
Yeah,
I was
they,
looking at this too generally.
yeah, I mean, it's, yeah, not through this ordinance.
So
This
there's,
ordinance doesn't regulate water
I got
quality.
I get what you're saying. Okay.
Now, those references though, so that's the way I phrased it, what is our role in that? So given that, and I'm glad you pointed out the water quality piece here, because I knew it was coming. But, so how do we? There probably be other items throughout this whole process we need to think about, but do we deal with this as a policy matter? So the board sets a policy and directs how the water engineer will handle it, or do we just assume the water engineer will figure it out?
So because this is in the technical expertise of the office of the engineer, it would be more akin to an engineer's policy, so an office of the engineer's policy. And that would be put into the recommended decision language as a conclusion of law from the office of the engineer.
On the front side, you get what we think is gonna work for each application type. When we go through the form filing process, we do look at each section of the ordinance at that time to see what we think we have in terms of water quality responsibilities. For instance, the maps and the setbacks imposed for domestic allowances, okay, incorporated. When we looked at the geothermal, there wasn't a lot there. You'll remember, Georgia, you asked us to look at that. So we are trying to fulfill our obligations in a stepwise fashion as we open the door to each new type of use or type of activity the office does. And all those forms need to get unanimous for approval, so that part of your review can happen at that first stage.
You know, any water quality questions that come up, I think are going to be a little tricky.
Yeah, the more I was thinking
Just-
about this, surface water is through the tribe's office, groundwater, the tribes don't have TAS for groundwater. So that,
Federal,
there we are.
maybe federal. I
That's,
don't-
yeah, I think you're right. I think you're right. Okay.
Any more comments or questions on those two forms?
This is why I'm so glad you.
All right, thank you. Next,
All right, let's turn to the, yeah, we'll turn to the notice of appeal to the engineer, so not to the board, but to the engineer.
color is that one? Oh, it's orange.
Okay,
I
so
don't see one.
this is, the reason why I have it as an example, so this would essentially just be a document for the public to access on the website. So they could download this, some district courts have access to pleadings like this. Essentially, it's just saying that they're, the applicant or the objector, if there is an objector, in this stage, is giving notice to the office of the engineer.
Pink, actually.
Oh, yes, yeah, that they, would like to appeal the decision, to the engineer to be reconsidered, essentially. What I will say is that the last line, should have on there, a request specifically to have a hearing. Just because you're filing a notice of appeal, that does not mean that a hearing has to happen under the ordinance. So if you're filing a notice of appeal to the engineer, One option could just be a determination on the record, which is essentially where on appeal, the engineer would look at all the paperwork and documentation submitted, the decisions that have already been granted or not, issued, I guess is the better term. And that's all that he has in front of him. On the decision on the record is what is termed in the ordinance. If you specifically want a hearing though, in front of the engineer, you do have to request that. And so that's why that last line on the notice of appeal is on there for specifically to request a hearing.
Is the hearing request refreshing, is that discretionary for the engineer, or is that if they request it, they get it?
Oh, I'm sorry, what was that?
The hearing request, is that a discretionary decision by the engineer, or if they request it, they get it?
So they can request it as long as it's within like the time frame that's within the ordinance. There's no language on whether it's discretionary or not from the engineer. Essentially, it just is plain in that if they request the hearing, they can get the hearing.
Is an applicant requesting a hearing? This be a hearing based on an appeal, about a decision, it's a recommendation to deny. To the applicant in the hearing phase, provide additional information.
There is an option to do that, yes. So it's kind of interesting, so if you have an appeal, right, so they file this notice of appeal. Signaling that they would like to appeal that decision to deny, let's say, recommended decision to deny. They file this notice of appeal, there's three options essentially. There's the record, or I'm sorry, determination on record or decision on the record. That's what I just referred to, where it's just documents in front of the engineer. That's what they're going off of. Another option is essentially where they can have a hearing with additional evidence and additional arguments presented. Now, what that means needs to be discussed. That still needs to be figured out by this office and legal counsel, what that standard means.
Is that in the ordinance?
The additional evidence and arguments, yes, it is. And then the third tract is just a standard hearing before the engineer. And so when that comes into play, that is just documents that were already submitted, determinations that were already made, and then arguments that they might give at the hearing, but based on only those documents in front of the engineer.
Are we, excuse me, Mr. Chairman,
Yes.
are we required to record the hearing or keep a record of the hearing, what occurred at the hearing?
Yes. Yes, so essentially, these documents too, all of these will go into a file for each application. And that will need to be kept with the office. And so then you'll need somebody to either transcribe or record the hearing. And that would be put in the file as well. And then that file, if it were way down the line being appealed to the board, is what the board would get.
And eventually, that whole file would go into the new storage system and be scanned in through the water rights database record to all eternity.
So we would probably need a court reporter for that function.
Nope,
No?
not typically. We fill out these papers, record the activities that happen there, generally like you would almost like minutes, but it's different. And then add that to the file on however the hearing outcome was. More interested, they're like, can we charge a fee for this? Because,
For like the filing,
yeah,
yes, you can.
okay. Sorry. It gets expensive when you start doing, I mean, if there's a budget, then we'd have to solicit additional help.
So, excuse me, if I could just, the objection to the application, so there we have a filing fee of $25. Is that set, that fee set?
It is not, no.
Okay, so these are fees that are not set by the
The language in the compact that talks about fees, I believe specifically references like water right applications off the reservation and does not tie into other non-water right applications. So this would be certainly a one-off. Whether or not there's some implied, urge to match, either, some kind of appropriation make up for the extra work or fees, something probably to budge. Jen.
Back to the additional evidence and argument. When the application says applicant requests a hearing. Yes or no? That's hearing. Should there be a separate line for going the other route, additional evidence and argument, or are they one and the same?
They are two separate processes and they should be separated on your flow chart.
But on the form. Applicant requests a hearing before the OA in this matter, that's hearing. Should there be a yes or no for additional evidence argument?
It would most likely, we could make it on a form, but yeah, we could just do that too. That's where I was mentioning, we do still need to come up with kind of what those guidelines are for additional evidence and arguments. Because that is an entirely different process and essentially it's. And then another step is added to it after that. That's a form that we'll discuss in just a bit coming, but that's the second recommended decision.
Yeah.
And so that is
See that.
administered by staff, not by the engineer, specifically. So that is an entirely different process. Essentially, it's kind of like a mini reevaluation of evidence. If you think about it, instead of going straight to a more adjudicatory role. Yeah, exactly.
So there should be another form.
There can be, yes, definitely.
I mean, I just. Looking at the way we're going here, it looks like maybe. A form to request that. Do they request that? With it, otherwise, how would they request that as opposed to a hearing?
Right, so we would be requested, but that's where we need to determine what
Okay.
the parameters of it are.
Okay,
Mr. Chairman.
yes,
Earlier, we spoke about standards of notice and how we give legal notice. Is there standards for the hearing? I mean, right?
Yep, so that's gonna be contained in this notice of hearing document that we'll get to
Okay.
just a second.
And my office will want to have a little say in the additional evidence because I don't really want to get into the habit of having somebody not fulfill their obligations to respond to a letter of defect and then get a denial and then coming back through the hearing process to, basically overcome the defect letter that never answered. Thinking out loud there.
that gets to be your question of standards, how we approach that, because under that. Theoretically. The Office of Engineer could deny additional evidence and argument,
Yeah, I mean, in that.
go straight to a hearing.
In that circumstance, though, if there was a notice of inadequacy sent out and there was no response, it wouldn't even get to an appeal to the engineer stage. Because that application would be denied with no response within that window.
But it still raises the question of whether or not we would be authorized to deny additional evidence arguments.
Yeah.
Yeah, Ken, did you have something?
Yeah, and I was gonna say that, you know, I think we could write into the form that the burden of proof is on the applicant to show that they had a good cause not to provide it the first time around.
No, I think that's really smart. I mean, that's something that, you know, I wrote down a couple times throughout this where the applicant does have to continue to meet that burden to produce this evidence of the wrong decision that they disagree with. So that is a continuous burden throughout this entire process that they need to have. They can't just come back and be like, well, fresh start. You know, they have to continue to prove that this is what's being affected and why.
Any more comments, questions on the notice of appeal to the engineer? All right, next.
All right, so
This is good.
we will go to, let's go to the notice of hearing, the Florida Water Engineer form. So Teresa, this will be, in line with what your questions were. Okay. So, this document. If we get to, appeal to the engineer. Which is through the notice of the appeal to the engineer form. The engineer grants hearing because it was requested on that form. So hearing is granted. This is the document that the office would be sending to that applicant and objector if there is an objector. This is essentially setting everything for the hearing. So it's gonna set on here, the time, the place, who the parties are, locations. So yeah, I mean, if you want to do Zoom, that's fine. Because of your capabilities with recording and having a transcript on recording, that can be done on Zoom to have the transcript. And then it also goes through rules and procedures that are typically done in hearings. So you'll notice on here like failure to appear. So if an applicant or an objector fails to appear, once hearing is set, that is right there, that determines what's going to happen. You also have what the purpose is. So on the second page, this is essentially going to list out your entire timeline for the hearing. So all the necessary steps for this hearing. And so these are what I want to note on here too. These are steps that are in a typical hearing procedure. We can, you know, take some out, add some in, whatever we want to do with that. What's best fit for the office and their function in the hearing process. But I just put that in there just so that we're aware of what actually goes into a hearing normally. Because it is a lot going into a hearing.
And the time frame is a lot.
So I have a question that I might be getting a little ahead of myself. This is really a good document. Really well done. Being a hearing examiner elsewhere. But the thing I asked, like I said, maybe I'm getting ahead of myself, but you said pre-trial expert testimony. Who's going to determine whether a person's an expert or not? I mean, is that, so he's going to go into a Daubert type hearing or something like that?
This is where that would need to be
Okay.
rules and procedures, I think, for what a technical expert would look like or qualify as. Because those are more so like operating rules and that, and so like civil procedure rules of Montana would most likely come into play with that.
So for the means that Ethan's going to decide whether a person that holds him out as an expert really is qualified expert, as accepted by this, whatever community he or she's part of.
Yes.
for you or for Karen or something, then having never been a part of one of these, how many staff do you usually need to pull this out? And where are we now?
This was to happen tomorrow. It'd just be me. In a room full of people.
But how many minimum do you need to have?
Are you just talking about the notice of hearing or the whole
To
process?
actually,
Actually,
yeah,
Probably similar to one of our meetings.
I think I could do 2. 3 would be better. But 2, me and somebody else.
okay. That helps me understand the scope.
But it
Thank you.
does, it would take a lot of time leading into this. I mean, that's what hurts, is the amount of preparation that we go into this and the documents and the. All the documents that we create for you guys, all the documents that we do for our water application, all of those things are just. They fill that finite window of opportunity to get things done, and this is one of those, the time sinks that we. It is also a little bit hard to run a hearing and then also provide your. To expert testimony on behalf of the office simultaneously, which is. That's kind of project, but probably okay. And is there a way to let somebody come in and provide testimony, but not necessarily acquiesce to the term expert?
Like a lay witness.
Yeah, I mean, or just like, I'll let you testify and, provide information, but. I'm not necessarily gonna, agree to some characterization of your status.
Informational witness as opposed to an expert witness.
Yeah,
Yeah, or like if somebody was attesting to historical, ownership of that water right or something, and it's like their uncle who owned it and they brought him in or whatever. Yeah, so that would be configured in that timeline. So the parties would have to disclose who they would be bringing for testimony, which would include both lay, and expert witnesses.
and just like from my perspective, I know that a couple of the things I said were pretty targeted at staving off, some what I think are some known polls. That said, I think for objections filed, lenience on standing is probably a good rule to a certain degree, and certainly the NRC has become much more lenient on standing over the years. But you might as well hear somebody if they've got an objection, as opposed to deny them their opportunity to speak, unless it's an obvious clear-cut constitutional or something like that. It's got an issue, and then also just for people wanting to come in and provide testimony, I wouldn't want folks to feel like they, I wouldn't want to set that bar too high to disallow information. So just want to like throw that in there in light of a few of the other ideas I have.
Question.
Yes.
So circling back to this definition of standing. There seems to be a real non-awareness of what that means, right? There's a lot of people that have objected to stuff lately just because they were against it, right? They didn't have a basis or anything in fact or reality. So do we need to have a definition of what standing means somewhere on the website? So folks, I don't know, I'm just throwing this out there. So if they have to have some kind of standing, whether you're lenient or not, does the general public need some assistance with understanding what that means?
It isn't our obligation to educate.
Yeah, I'm asking, just pretending I know that I'm ignorant on this, so.
I think you're talking about two things here. Now,
Okay.
standing, you have to have standing to bring the action in the first place. It gives a court jurisdiction. But what Ethan's talking about is, I have standing, but I want my friends and relatives to testify, and it's marginally relevant. The hearing officer has the discretion to let it in.
So going back to the former one. Do we need to educate the public on what the term standing means? So they're not just objecting to things just to object to things. Or I'm just asking.
So, one thing that was helpful, so I handled a lot of these when I was doing the implementation of US Forest Service Compact, and there's a fair number of objections to water right applications for history and claims of the filing of the water right compact. Now that compact had really specific criteria that you had to object to, so it made it easy. But would you object to these criteria? I don't know if this ordinance sets things forward like that as clearly, so I'll be rereading with his prompting here to see if there's any opportunity there. But generally, obviously the water code's been pretty what they determined is objection to.
But they've also gotten a bunch of objections. Right? And that's more work with them.
Exactly, it seems like it makes sense to do some public education, because it's preventative. So that you don't have all the objections moving forward necessarily.
I think the committee has been established.
I'm just thinking about staff, right?
I tend to agree with all of that as well, but I want to turn to Haley and ask standing. There must be some legal framework for that as well.
There was until last month.
That's not a good sign.
This is why I, stated for, when you're talking about saying that it is a concept that is oftentimes litigated about. It is a complex issue, and there are different types of standing. There's constitutional standing, there's just basic standing, there's corporational standing. So there's all these different standards for it. With standing though, it is the decisional body's prerogative to make that determination.
Can we define it?
I would not define standing out for the public, no. No, because that is an entirely like case law based, statutory based framework that's already out for the public to see and view. And so how how we define that and how the office defines it, or even the board defines that, I don't think is something that we would necessarily want to put out.
Question, so these forms are all gonna be on your website, right?
I mean, some final version of it,
Yeah, that's what I
certainly,
mean.
yeah,
And
yeah.
the first form said this is what you need to do to file an objection, you need standing. I think that's adequate because it says, this, I think, as much as you really safely can say in your defining standing.
Yeah, we try to provide a few leading questions to get people in the right pocket if, to figure out whether they have standing or not. But,
Given that, I heard your comment about being a little more liberal when it comes to accepting standing. I don't know what that means. That's the one I don't know.
Sure, so what I meant is, you can either have some like tight constraints on whether or not. Like earlier on in some of the water right work that I did, you had to have a water right. And that water right had to be within the influence area of the water right that was being proposed to be granted. So there's a very tight, group of things there. Now then, things started to blossom where you started having in-stream flow groups who didn't have a water right, but had an interest in the water that was in the stream for different reasons. Okay, and so like that would be an example in my bad jargoning, I apologize for it, but where, you go from a fairly confined definition of who has standing to a little more of a more liberal approach where this person didn't actually have to have all the water right, they just had to have some interest in what happens with water in that stream. Does that help at all? Maybe
Yes and no. Yes, because I understand it. No, because I'm not sure I agree with it.
Well, the courts certainly opened it up a little bit on that particular issue. That you don't have to have a water right to be able to file an objection. And so there's within somewhere between that and I just don't like this person. This magical line that will have to be found.
It'd be good to have more of that discussion then at some point, because I don't know if somebody wants to object, but isn't. Maybe they may, have an interest in stream flows, but. If I'm not affected by it, don't have the water right. We really need to define how that's gonna work.
No surprise that I am very aware that you will direct how I'm gonna look at what meets the standard criteria on that general direction sets. So I'm
when I say I don't,
I have an idea here.
yeah, when I say I don't agree, I just say on its face, because I don't have all the details, and I think we need to have that discussion. So, yeah, Teresa.
I understood it slightly differently. I understood that the standing issue was fairly firm, but the leniency was exercised at the hearing as to who could offer supporting testimony or evidence.
I did say both things in
Sorry.
one pretty closely grouped set of things. So and I also will remind everybody that just because you decide that an objector has standing, it doesn't mean that their objection is valid.
Yes.
So that's an important thing. Just I want to clear that up. So you really on the standing issue is like, are you going to let them come and make their case or not? That's really what happens there. So there's no predicated, rule to allow their objection to move forward. And then on who could provide testimony, I did also suggest that there might be some circumstances where I might hear what somebody had to say, even though maybe I didn't think they were as much of an expert as they thought they were. Sometimes you have to hear people coming out of their guts and burden information.
Yeah.
And I worry it gets called slippery slope. Somebody can come in and say, I fished that stream, and now I can't fish it anymore.
Sure.
Well, that it's maybe related to what I'm thinking. And I think that's gonna be a very good example of the kind of potential pre-decision communication between your office and our legal staff. That could get really convoluted. Well, I don't want to make it convoluted, but I think that because Ethan calls up, say, I got this, here's the facts, and I'm leaning toward, saying this person has standing, or I'm leaning toward this person not having standing. And he's gonna ask for a legal opinion on it.
Which does commonly happen over at the NRC. But
You're shaking your head.
she's not gonna help me on that.
Here, so I'll kind of clarify
Well,
your concern too.
which gets to, you just round that out, and then the slippery slope part in my mind is once you open the door to one, then all the rest gonna want to come in under that. And if you open a little more, then that's a little more, and how do you, is it even possible to close the door once you open it when it comes to standing?
So two pieces here quickly. With the floodgates opening. People have a right to object. So that's a standard, right? So that's like with the water court. Going through all that stuff and all these objectors, even though they might not be valid objections, like Ethan was talking about, they still have the right to object. But the office does have the decisional opportunity to deny that based on standing. Which leads into my second comment. The ordinance accounted for that situation, because if somebody objects. And the office determines you don't have standing, we're denying your objection, here's our final order saying that and why, they can appeal to the board.
Okay. Can I add one thing?
Yes,
If someone files an objection, and you have questions about standing, I think it's within your right as a hearing examiner to have both sides brief.
And both
Both
sides,
sides brief it. Do we have standing or not here? Let them make the arguments for you, and then you decide which argument you like the best. Or feel legally sound.
But all of that takes time.
Sure.
And that's what I'm concerned about with the small staff and looking out for our staff and making sure they're okay. And I don't know enough about this I'm just asking the questions, but those are the basis of my questions, is that concern for our staff. So
we're right on questions, but we're not fully staffed yet. We will be more fully staffed here as this proceeds, correct?
yes, sir.
Yeah.
just keep reassuring them of that.
I will urge a little expediency on our hearings documents. We're running quickly out of time, or I'm gonna keep you here quite late tonight.
Oh, you mean today? Well,
Yeah.
we can end anytime.
Yes.
All right, that was it. Notice of hearing before, what, any more comments? That one deserves some reading. That one's a little more lengthy. It's got some pages to it.
Yeah. I would definitely take a look at this, when you have some time. It is kind of more of a procedural document for the
Okay.
office of the engineer, so.
Perfect,
please
thank
do
you,
that.
thank you.
So I only have a couple more in terms of the, engineer, office of the engineer, procedures. So just quickly, we can do the second recommended decision. So I briefly mentioned this document when we were discussing the concept of additional evidence, and argument as well in that, kind of process from the appeal to the engineer. This is the decisional document that is going to be issued by staff of the office of the engineer. If it were to go into that circumstance where there is additional argument, and evidence presented after notice of appeal, the engineer's filed.
And the staff makes the recommendation to the engineer, or they make a decision?
They make it to the engineer, yes. Yep, so in this process, you'll have a recommended decision to deny, let's just say. And then they appeal to the engineer and are request to put in additional evidence and argument. Once that's done, you'll have this decisional document, which is from staff. And then that decisional document will then go to the engineer. The engineer will then make a decision off that. And you can even have a hearing on the second recommended decision to deny, grant conditions, what have you. And that all becomes part of the record for the engineer on his review after this stage. This is, just to note, this is a shorter document than the actual first recommended decision. Because it is a review of the record and then additional evidence that might come in, and so essentially it's just going through what's already been determined by just adding in, slots here and there for additional evidence and argument, and that's why it is a little bit shorter. Because it's going to be pretty much in line with the recommended decision. So
Speaking of public awareness and public ability to have a second bite at the apple, this is pretty unusual for myself. So it's extremely fair to be able to have that opportunity, because typically, I think places, organizations, ordinances, who are boards that are managing other regulatory authorities don't typically allow a second bite. This is in my head, second bite at the apple if you missed the first time.
Yeah, it would, there are processes within the ordinance that, do really let an applicant or an objector continue down multiple appeal processes. So, I mean, in this situation, yeah, you could have an appeal to the engineer, then you could have, that second recommended decision issued, right? And then that's essentially the engineer taking a look at it again. That could then be appealed to the board, and then going through that whole process, that could be appealed to a court of competent jurisdiction.
I know we're running long. No, we started late. Do you need a break?
I do.
You tried? All right,
Yes.
we would like to hit pause, take a 10-minute break. Thank you very much. How many do you have online?
We have 3 online, they're all staff members.
Okay, we'll take a break. Thank you.
And then Ben.
After a quick break, we were on the second recommended decision. Unless there's any more comments on that, we can move on to whatever form next. So go ahead and continue.
Great. We can turn to the final order document. And for reference on your flow chart, that's all of the teal ovals. You will notice that there are a lot of those situations on the flow chart. Because this is essentially an appealable document. So this final order that's issued from the Office of the Engineer is what would be appealed to the board. Again, essentially this is tailored to provide the background and procedural history of the application, if there was a hearing, all of that such. There's a legal standard, which again, that will still need to be tailored between legal counsel and Office of Engineer. But that will just be set, and it's essentially what the office will be using to base their decision off of, their final order. There will be a discussion, so that's where facts and legal conclusions can be brought into play. And then the final order section on here will just be what the actual decision is, the final decision of the office. And then there's also, if you notice here too, in the brackets, I put on there for listing conditions. Because there might be applications where the final order is going to need to grant something with conditions. And then on appeal, those conditions can essentially be appealed. One other thing to note too, this does also have a notice section as well on the document. That is for the parties that are involved in this final order process. It does also lay out the time frame they have to appeal to the board. So they only have 30 days from the issuance of this final order to appeal to the board.
Oh, thank you.
That was the final order. Any questions or comments? Not at this time.
Thank you. This document seems to be geared towards decisions about applications. We use something similar for other types of decisions about compliance and things like that.
Yes. And to differentiate too from, if there's an application that's deemed denied or if an application is withdrawn, the closing letter is different than a final order.
Okay.
So the closing letter is just gonna be an administrative letter that says what happened and that the matter is closed. We'll get to that one, it's this last one here. But the final order is an actual decisional document that can be appealed.
So, questions, are you incorporating the recommended decisions into this? You don't have, okay,
Yes, yeah, it would all be considered part of the record at this stage, so yes, it would be considered.
but it'd be incorporated to this actual final order. Okay.
Yes.
Going once. Twice. All right, thank you.
Okay, just two more forms for the hearing process, hearing examination process. So we'll do, well, actually, let's touch on closing order. We'll wait for the other one. So closing order, that's what I was just talking about. That's in situations where if there is a recommended decision, the applicant withdraws their application. That matter is concluded because they do a conscious act of withdrawing their application. So there is no final order, there's no decision, nothing to consider. And it also comes up in a situation where the application is just deemed denied outright. That's also defined, that process is defined in the ordinance as well. So there is that situation. And so that's where these come up, is just basically saying what happened. And the matter is closed, there's no need for further action.
So this is only if you grant the application.
Withdraw.
No, so it does come up in, the decision to deny,
Deny.
grant with conditions, we haven't even touched on this, and I'm not going to today, but a mitigations plan scenario. So the closing, letters are those like dark ovals on the flow chart. So there are quite a few of them.
Should the closing order then reference that no appeal has been filed?
So you cannot, are you talking about appealing this closing order?
No, just closing order should reference the fact that no appeal has been filed.
It can most certainly reference that. I don't think there would be a need to, because where these closing orders come up would not necessarily get to the stage of an appeal. If it got to that stage though, then yes, it would need to be put in here where it says provide procedural background.
Okay.
Yeah.
Okay.
So the closing letter on this chart is the closing order.
Yes, when we do finalizing and everything, the terminology will most certainly mirror on documents. Thank you for pointing that out.
Thank you.
Yeah.
Okay, final document for the hearing process. Now this is kind of a transition, document. We're on the notice of appeal to the board document. So again, I have example at the top because this would also be a document that we could put on the website, for anyone who wants to appeal to download and fill out, to then file. This would be done with whoever's going to do document receiving for the board. So whether that's somebody who's going to essentially act as a clerk for the board in an appeal process, that would essentially be who collects this form and gives it to the board. This is different, you'll notice, the terminology changes at this point, as per the ordinance as well. The parties, instead of applicant and objector, are now referred to as appellant and appellee. So similar to any sort of appellate procedure you see in any sort of court.
Is there gonna be any problem with our office designating somebody to serve as the board's clerk here in house?
If they're just doing administrative filing and retention, no. Having yourself or somebody who made the second recommended decision probably won't be just on its face good, but
All right,
that would be more so an office policy and board policy to do that.
I'm just thinking of logistics wise, I don't know who you're gonna get to do this for you, so, unless we're gonna hire somebody else then.
I think I heard her say, well, you're gonna get.
All right, there we go. Right down,
yeah.
another job, assignment.
I thought you were gonna have me put it in the compliance tab.
Yeah, pretty much.
Okay, I got it down.
Yeah.
So in Crow, I have a civil court clerk, and I just started calling her appellate clerk and stuck.
Yeah, I mean, you can have an administrative personnel in both of those scenarios. I mean, we're just doing file retention and recording, and that's one function, that's not anything decisional. Again, you'll also know that there is there should be a request at the bottom for oral argument that does specifically need to be requested by an appellant from the ordinance. So if they don't request an oral argument, this board can make a decision based on the record below. Or on its own prerogative, can decide to have oral argument.
So if Ethan makes a decision or hearing, that the person on the objection is, stand. Is there an opportunity for like an interlocutory appeal, rather as opposed to going through the whole process?
Could you say that one more time for me?
Sure. Is there an opportunity, if you make a procedural decision right at the beginning,
Yeah,
I don't have standing, which means I can't participate. Can I go to the board and say, I want to appeal that procedural decision? Or would I have to go through or allow the whole process to play out before I can do that?
possibly even asking for an injunction or something equivalent to stop the, so that the proceeding wouldn't go forward without your participation.
I don't know if it'd be more of an injunction, just
Delay.
appeals court say, yeah, you do have standing.
Okay,
Yeah, so in, like, for example, in an objection situation where there is that clear question of, do you have standing to bring this objection? If the office decided, no, on its face, we don't have standing, here's why, that's in that final order. That is completely appealable to the board on just the procedural question of standing.
But if there was other parties involved that did have standing, you wouldn't have such a clear cut order. I guess that's right.
Right, so it would have to be, I mean, that would have to be a case by case
Okay.
situation, when it comes to it, there is no such. I guess, pathway in the ordinance that specifically says, yeah, you could just go right ahead with a procedural appeal. In this situation, but, if that was the case where that was decided on, that is most certainly an appealable issue that the board can decide.
Well, that, in that particular case, then I would think that would kind of fiddle with timelines then, right?
Yes,
For those individuals who
It
actually
could.
have standing,
it could potentially,
or for the staff.
I mean, there are also documents, when there's appeals filed and such they're called motions to stay. And so if somebody were to appeal a standing decision to the board, they could file a motion for stay with the office of the engineer, which essentially says, hold off on everything that's going on in your office right now, because I'm up here dealing with this appeal on this issue. And once that's decided, we can come back and maybe we go through that, or maybe the board said, no, we agree, we don't think you have standing.
Clear as mud.
See, just because we're moving arrows, and I know I'm trying to hurry us along too, but, when I read the flow chart, it looks like somebody has got, if I was to issue a recommended decision to deny, it looks almost like they have to appeal to the engineer before getting to appeal to the board.
Yes.
That's true, like,
Yes.
they actually have to appeal the engineer.
Yeah, if you issued
First.
a recommended decision, yes.
Mandatory step. Okay, thank you. Then it's an accurate flow chart. We'll make sure.
But for me,
Any more? Good.
Okay,
Good as we can be today.
yeah, it's. So while that was a lot of, discussion with specifics and such, please take the time, to go through those. And provide any feedback to, Ethan, please. And then we can have those discussions separately from this board.
Since I couldn't color code the forms, I numbered them on here, so I numbered them there so I can reference them. So
Perfect.
kind of hard to made my own key.
So
Is there more?
not in the hearing examination process, and we can touch on these board, documents fairly quickly. The two things I want to bring up. So one you have before you, which, again, this is very draft form. So I'm going off of, similar judicial codes, in particular. This was taken from both the, CSKT appellate code and from the Montana Supreme Court appellate code. So it is a amalgamation of both.
So on our agenda, we're on to 4.2.
Correct.
Okay.
Essentially, this document came up in conversation from the last time we met, where this is going to essentially govern a board member in their adjudicatory role. Now, while it is a limited role, for the ordinance, it seems fitting that a board member would need these protections, as an appellate body. And guidelines, like, so for example, there's about impartiality and fairness, in here. There's parts about ex parte communications, so having communications outside board members. And what we can and can't do with that. So that's the basis of that document. So if board members would take the time to provide, you can provide me directly, with that feedback, please. Any conversations with this, would be needed to have between us, and the board.
So just for clarity here, the title of this says appellate judicial code. The agenda says which one of these is it?
It's the first one, the board adjudicatory code of ethics. and-
Okay,
And that had changed, we were playing, sorry, and when I refer to we, I'm also referring to other legal counsel, John Teets, who works with me, we were playing around with names, of what to call this document, and I think the code of ethics is a more appropriate document, name, and so that's what was submitted, when I submitted agenda items.
thank you.
Mr. Chairman, board members, we would, I assume, convert this to a resolution eventually. That would be where it fits in our organizational structure for documents.
Yeah, if that's how, since the board decided on doing resolutions in terms of formalizing procedures and policies, then yes.
I make a suggestion. Did you add in your definitions expressly authorized by law? What that means?
I could most certainly, that,
Because as it's written now, I would have to give up my other jobs. Could
Yes.
you highlight what you're talking about here? Oh, it's in 3.5. The not perform as a mediator from other judicial functions apart from the board members' special duties unless expressly authorized by law.
And what do you want to find?
What does expressly authorized by law mean? In terms of this document?
yes, yep, yeah, and in connection with the compact and the ordinance as well, yeah. Also to keep in mind when you're reviewing this, this is based on two documents that are not board documents, and so language, what sections are in here, that's all gonna be determined by the board. This is more so a template to work off of.
So even though, in fact, I'm just catching this. Most of these are labeled draft, this one's not, so
Yeah, I don't know how the watermark can make it on this one, so
but this is draft, right?
it is. That's probably my program, not.
Well, am I the only one here that doesn't know what invidious means? Anybody know what invidious means?
Where is that?
3.4. I had to look it up. Georgia would probably look it up first.
I haven't got that far yet, so.
Isn't that obvious?
Well, it kind of is, in kind of a roundabout way.
Yeah, it might be a good one to define, I don't know.
Well, I don't know if it's necessary
It's
to
more
define.
so colorful language, it's not necessarily a defining term. But this document too is something that we would set aside, to discuss, board direction and opinion in a closed litigation session.
One more comment. I do have a problem with the last sentence of 3.6.
Oh,
I just, in, small towns, lawyers represent their family. So I just has, we can do this further discussion. It's just, I had a question about why that was necessary, that you don't have to answer now.
yeah, sure, I'll flag it.
Could you clarify what your concern is?
Sure, I represent my daughters, I represent my wife, I represent my wife's trust. They're all family members. And I do it as counsel. Sometimes they pay me, more often they don't. And that would preclude me from helping my family.
Like, within the context of this board?
Yeah, that's I guess my question. It's much broader than that.
Yes,
I would
yes.
not represent my family before this board. I just
Right.
wouldn't.
right.
Okay, and I don't even mind a prohibition about this board, but when you go into other aspects of life, it's just a
Yes.
little broad.
Okay, thank you.
So I do want to make a just clarifying statement too. This ethics guide is in the context of only your adjudicatory role pursuant to the compact and the ordinance. So whether there's going to be some like precursory language in there saying that this only applies in those situations, then that would resolve that issue with it being pending and impending cases before the board. So some of that language, but just wanted to reiterate that this document is only in that context, not for, going out and being an adjudicatory figure outside of the board, so.
Quite a bit to get through there, so if you have more questions, do it now, otherwise we'll move on. You're good. Lisa, Roger? We're good? All right, thank you.
The final thing that I want to just bring to the board's attention, is this concept of appellate procedures. So there is no document for it, before the board, right now. Essentially, what I'm getting at, and this will have to be a conversation that we have in that closed litigation session that the board will schedule. That's going to look at essentially how the appellate procedures will go. So what the scope of appeal is, what the like I talked about the stay, motion for stay of the engineer's decision pending an appeal. That's something that will be determined. What's the record look like on appeal? What is additional evidence? What does service of process look like? Those types of things that are specific to an appellate procedure in front of the board. It will also discuss like representation by counsel in an appellate procedure before the board. So what that would look like. And then also, for example, what side, so like, does the appellant get 45 minutes to make their oral argument and the appellant gets 35 or what have you? How that whole process works. So that will be a discussion that we will have, but I just wanted to get that concept on the table. Because those are things that are not defined in the ordinance or the compact at all. And the appeal procedure in the compact is very minimal. So that's going to be a lot of board decision and discretion in creating that. And so I just wanted to get that on your radar to maybe come up with some ideas prior to the meeting and what have you.
One of the, I guess, things that keeps, and I don't know, I don't have a running list, but as we move through this, we should try to keep a list of those things we may eventually recommend to the tribe and the state for amendments to the ordinance or come back. So and maybe there's something there. Once we get through it, we could tighten it up and in the future have that. But I don't know if you're keeping track, but we should probably,
I have my own list, Mr. Chairman.
we should probably have that discussion at some point.
Question?
Yes.
Do we ever, Is this ever referenced in the board's bylaws? Is there any conflict between this and our board bylaws? It seems like we should look at those two documents side by side.
Yes, so that will need to be done when we have that meeting in terms of matching them up.
That's
to make
right.
sure that we're citing to
That's
those. Yeah, the citations will need to be in that code of ethics.
That's
all
right.
over the place. Yes, so great observation.
Comment?
Yes,
Number one, I think we have the authority to implement these administrative procedures without going to the state or the tribes. So I'm strongly in favor of doing this ourselves. Put something together that we can use and know what our parameters were. I don't know if we have to get into length of hearings and that kind of infinite detail, but I think, and it helps us and it helps the public too. They know when they have to file, what they have to file, so on and so forth.
yeah, and I think you're probably gonna look to all of their resources for guidance because it's all been established. Hearings, procedures and so on and so forth are already in place in many places for us to consider when we develop this, but we do need to have it stand alone.
Yes, and both documents that I pulled from, again, were the appellate code from CSKT and the appellate code from the Montana Supreme Court. Because there's two appellate bodies, so it's not district court, it's not lower court. These are appellate procedures, which are different. And so anything that we put in here would be based on those two documents and the citations to the ordinance and specifics of the ordinance for the compact. But yes, those are standalone procedural documents. They are not necessarily put into like the constitution or bylaws or what have you, ordinances of other government bodies. They're separate standalone policy and procedure documents.
Probably already thought of this, I would look at the federal rules, all the procedure too.
Yes, they've been like that.
Okay.
Yeah.
More comments, questions? Again, more to get through, so. Thank you. Hopefully we're tracking and giving you what you need as well.
Yes, please. I welcome any questions too. If anything comes up, feel free to email me.
Very good. Ethan? How we doing?
Mr. Chairman, we're an hour behind schedule.
Oh, we're right on.
Yep.
All right, anything else, Haley?
No, I will gladly sit back.
Okay. Good, thank you. So
Thank you.
that brings us through 4 points up to number 5, emergency fire use reporting for fire uses. Mr. James Frank. So it says remove this if necessary. Hopefully, we're not talking about James Franks.
Well, maybe. Thank you, Mr. Briggs. You want to stand here at the top? Yeah, anyway, sir.
Thank you, board members. Next is, should be a fairly quick little form for your consideration. This is the temporary emergency appropriations form. This was brought to our attention by Kathy Schubert, actually, as we started to make improvements to the database. This was an outstanding form that we needed to kind of push along, but also it's not super pressing that we get this thing out there and happening necessarily right away. Just a few things to notice. This is just mostly a tracking form. So if you take a look at the last 2 pages, this is going to be used by people who are fighting fire mostly. And we just are using this in a way to track the amount of our use. Because of that intention, we've tried to make it as simple as possible. Something that somebody out in the field sort of handle quickly. And we're just trying to gather the amount of information, the least amount of information necessary to get accurate data without causing too much of a burden on these people. On the front of the form, you'll notice that firefighters can use pretty much any source they need to fight fire. There's no filing fee associated with this kind of form. Happy to take comments or questions at this time.
Question. Why, this doesn't seem to track your normal form numbers?
Yes, that's because this wouldn't be a form that would be publicly searchable through the water rights database.
I'll offer more a little extra context. This is a discussion that we had at our last board meeting, and we had hoped board member Shane Henderson would be here today. You may end up helping this until some other meeting, but we were really prepared to give you the option of a form if, in fact, after hearing what Shane had to say, if we needed to move forward. We still, because of the no staffing issues, would hope to deprioritize the collection of this information if left up to us, but should tribal staff or EIA staff or other folks want to really go gung ho and have some kind of a tool in which they could solicit this information that is technically required by the ordinance, we are in fact prepared. Sorry, to add that context.
So when it says, any use of water, this is groundwater or surface water, or just from a well?
This, I believe, is any source that they can tap into. There are some limitations. If it's not a fire agency, you're not allowed to use enclosed storage. And that's listed there in the report box. But yeah, if there's an active fire, they can use whatever source of water.
Not allowed to use enclosed storage. And then it says water used to fill tank or storage. What's the difference?
This would be for firefighting fire departments to use that. So that's an exception to the rule.
So what enclosed storage would they not be allowed to use?
The only people who wouldn't be allowed to use enclosed storage would be anyone who is not a local governmental fire agency.
And this is required by the ordinance that we have a form in place. Okay. I was just, I just think out loud. I've been watching the planes land on, scoop water up out of Platinum Lake, and I'm just thinking, how would you do your quarter section? How do you fill out the legal description when you're scooping over? And how critical is it that they have that really accurate? This is just getting some idea of water, right? So we're not gonna have heartburn over legal descriptions or.
I think the idea of this is to be more coarse than per se a new authority. For instance, notice like in that section, we have county and nearest towns.
Under emergency description, they could put flooded lake.
Yeah, for instance, that would work.
I mean, or maybe there's, to your point, place they could just write flooded lake.
Right.
Yeah, so that would be like source name.
Yeah.
So that's really the incident location. So where the fire is.
Okay.
So, sorry, I wanted to make sure before I start with my mouth, but, they'll know where the fire is. They'll have that on their map. And they can give us a general idea. That's, I think, enough.
Okay, gotcha. I misunderstood that. So thank you.
And then sources. Yes.
So if this was approved, we'd ship this out to folks today.
No, that's what Ethan was saying. I think at a previous meeting, we had discussed like, this is something that's good to have, but we don't necessarily need to roll this out right away.
Good to have.
Again, we didn't know Shane was not gonna be here, but we went ahead and moved forward. We understood, it was mostly Teresa's good idea to get his input on it. I did, see if he would be able to provide us, comments about it, and he didn't get to it before this meeting. Up to the board on how they'd like to handle things, but, we aim please, we'll do whatever you want.
It might be interesting to take a draft and even before we approve it and hand it to them and say, you know, do a pilot run based on what they've done already, what would it look like? Just to see what it looks like, because I mean, they'd fill out a number of sheets based on this year's activities.
Mr. Chair, board members, before we go out to the public with the form, we really would need to approve it. You can always modify your form later, but.
Oh, yeah, not the public, I mean,
Okay.
As a Shane or somebody or.
A test.
Yeah, you say, hey, take a look at this, we're looking at this,
I
you
understand.
know,
Okay.
take a shot at fill us out, take a stab at filling this out for one of your fires.
Sure.
Or send it back so we can take a look and see what it looks like, because there
Right
might be.
by the little arrow to the fire camp in Arley all the time.
Yeah, it might be, you know, something they might look at and just chuck it, or. You might look at it and say, yeah, we can do this, and I wouldn't do it as a formal public notice thing, just. Just a thought, just a. Or take a stab at it yourself.
Mr. Chairman,
Yeah,
respectfully, sort of disagree with you. I think this form is so simple and easy to fill out and so basic. It's just something we can
that's
just,
fine,
you know, I don't think we need to do all that.
that's fine. Just a thought, I'm not proposing you, just. All right, anything else on that form?
Nope, it's
Anybody?
up for you to make a decision on if you'd like, or feel free to pass on it and we can bring it back up at a later board meeting.
I think one of the ideas was to have Shane weigh in, or you want to wait for Shane?
Yeah, it seems like it has the most bearing on, you know, his team. But I want to thank you for putting all that together, of course.
All right, thank you very much.
Absolutely.
All right, thank you.
Mr. Grace.
Let's take good care of it now.
So it is, just a footnote here, it is after 5. Our idea is that we would run till 6. We can run till less than 6 or up to 6. Just to touch base, I'm assuming y'all want to end at 6 regardless of where we're at here. Board members?
I'm good with staying till 6 if that's what the majority wants.
I'm good with 6. I can stay later if we need to.
Yeah. Our agenda says 6.
Okay. All right. Good.
I'm here all night if you'll stay. Mr. Chairman.
Yes. Yeah, 6:30 is on the agenda.
Is it? Okay. Then it's 6:30. All right.
6 is great, though.
All right.
Item number 6.
Mr. Chairman, board members, this form is in direct response to what folks need. If they're looking to do a property line change or subdivision, and they have a water right that is an existing and active water right. DEQ calls for comment that would verify whether or not their existing and active water right, if it's part of their proposed boundary line adjustment project, if it's a legitimate water right. We have helped a lot of folks who are in this situation with these pending subdivisions by giving them a resolution to pending registrations for a water use that was for before the effective date. We have given a lot of folks help by issuing them authorization to drill a new
domestic allowance, either shared or individual, through the ordinance and the procedures that you've approved so far. If we were to, have this form in hand, we would be able to address this one other category. Now Haley may not remember, but she did do a bit of a draft memo work up for us on this, and you know, we didn't really finalize the draft memo, and I don't think we need to. The answer was pretty straightforward, that it's within this office's and your board's authority to make a determination about an existing water right for this particular function. I hope that I've done a decent job introducing the form. I will certainly stand for questions or suggested edits, and we did in fact grab this filing fee out of thin air. The DNRC has a different predetermination arrangement with DEQ. And they don't, I'm not sure that they even charge, but we believe that this is a fair amount of work, and we'd like to have a little something to help us along. It would at least at a minimum help to pay the access to county databases that we use to research the information when we decide to do some work like this.
You just said out of thin air, but why not? So why not 50? Why not 100? You land on 65 for a reason.
Seemed like this would be easier than a water right application, but harder than a withdrawal.
Okay.
So we sort of
Just
split
split
the difference.
Okay. Yep. Okay.
So last summer, we had, you know, comment after comment about people who were trying to subdivide their properties for their children and so on. Is this the response to the?
Yes, sir.
Thank you.
And you've been helping them along the way as it is.
Unless they have an existing water right that needs comment, because we don't have a process set forth. This would be the board giving me direct authorization to handle that. Now, keep in mind that some of those situations aren't as clear cut. As you'll remember, Mr. Smith's water right was determined by the Department of Natural Resources and Conservation to be non-valid, even though it had gone through years and years of ownership updates. And so I don't want you to act without realizing that this, you know, this is it's an undertaking, but it is something that, you know, citizens living on the reservation need access to.
I just had a question, if you've covered this, my apologies. Why is it called a DEQ subdivision and not just the subdivision?
Ultimately, the subdivision law is governed by DEQ, and we wanted to make this a bright and clear indicator that this is the type of thing that we'll look at a verification for a water right for, and that we will not do this for speculation or somebody looking to purchase property or other reasons that somebody might so choose for this office to come in and do some sort of a water right research verification step for them.
So then a DEQ subdivision has a number or has a process, so it's like testing or.
Yeah, and they have a very specific part of their process that requires them to go, I think in their administrative rule, last time I checked, it specifically cited to DNRC, but my understanding, I haven't been tracking it, is that they were going to make an attempt to update that in a way that would allow for our office to interact with them, and I certainly know that they have been allowing our office to interact with them on these water right issues.
Maybe your question is DEQ says it's not a DEQ subdivision. The subdivision,
Okay,
but they're required,
rephrase that. Yes,
they're
okay.
required to provide the information for DEQ purposes.
For
I'm not sure
DEQ
what-
subdivision applications. Or something like that.
Right,
We'll
whatever.
absolutely make that change. I thank you, Mr. Chairman.
I think that's what you're.
Mickey, sorry, I missed that.
Take your comment. Yep, I don't like acronyms without an accurate explanation.
Yes, sir, we can get that in there. Montana Department of Environmental Quality will be in the title.
I don't.
And I'll scroll down here since I can see at least Ken's looking at it on the big screen, and he is excellent at catching things we have not caught. You'll notice that right here, we try to show that if you have a suspended right, that's a different, that's a different item. And that if your water is provided by a public water supply, we need to know what's going on there.
So this is a dumb question. On other applications we've asked for that long. Is this something that's just not appropriate for this application, or is it something we shouldn't have?
Yeah, it's not a bad deal. It's that long. It's not a dumb question. I think it's a good catch, actually.
Well, it's dumb because I didn't know the answer.
Well, we try to manage the volume. Sometimes we miss a few of the details along the way, so we need this kind of review and appreciate this kind of review. And we for what it's worth, we do typically give these a really hard look over for grammatical and formats. We try to catch it, but obviously we have a lot of moving parts here in this office. This is something that it's nice. We've got a big project information section on that we fill stuff out.
One more.
Yeah.
Can you go back?
This one.
Could you move that last sentence to the next page?
Yes, sir. So- Oh, yeah, it looks like we need to do that. Good catch there. We should just send the forms specifically to Ken in advance of the meeting.
Under number one, you may just want to tighten up your formatting for zip and email it.
Yeah, it does look like we got a little goof up there. Thank you. It looks like we've got too many spaces in there.
I haven't caught it because those happen to me all the time.
Yeah, well, trying to make a form like this is kind of a nightmare, honestly. So, and sometimes we're not exactly sure how well we received, so we spend a decent amount of time, so it's got a good bones to it, you know, and get the wording and everything right. And if we're generally go on the content, we'll try to tidy it up. But, this is just our standard signature block here. There's nothing fancy. You've seen that before. Hopefully it's a copy and paste. That's what I have for you on this form, unless you'd like me to go to some other part.
Yes, you go up a little bit. So you didn't make my change.
I didn't. Oh, no, I am writing it on
Oh,
here.
okay.
This is actually a PDF.
Okay.
It's yeah, and so I've got the changes that you wanted. I took notes here on this text, and we're gonna make those changes after the meeting with you. I also noticed that we inadvertently put draft watermark on this, but hey, it's here.
Could you just, I know Ken asked, but remind me how this is mechanically gonna work?
Somebody
Use of this form.
Somebody gets about this deep in a DEQ subdivision application and realizes they needed to do something with their water rights. And then they usually they go ask 3 other offices, which aren't the right office before they get here. Then they ask us and we say, well, we're not providing that kind of comment at this time. We can fix your new use. We can fix your suspended use, but we can't fix your existing use in terms of your application. Now, we have a different answer when they come to us. So mechanically, we may end up with somebody who has a subdivision that has an application for a new domestic allowance, verification of their existing one, and maybe a request to move their registered use. There could be all three items that need to be intended for them to be able to jump through DEQ. So, and this could be some simple stuff, like just a lot line shift 20 feet to the left. Okay, so that comes under the same review standards as I'm trying to do something bigger. And nothing in here like opens the door to some kind of larger activity than you would expect. This is look at existing water rights. We would look at them the way they compact and intended us to, if they would be they're valid and legal and properly filed and everything would be considered legal.
So it's information the applicant needs to provide to DEQ so that they can complete their subdivision process, for
Yes.
example. So as an application, are they filling this out or are we?
They are filling this out, and then the response will come as a letter from our office at present, written by me. We might expand that sometime in the future, but on our letterhead, that would be a direct response that would describe what we found when we took a look at the specific water right that they asked us to look at. And we would then take a copy of that and this application that would be date stamped. We would add this to the file that is associated with the water right. Probably have to do a little help with Ben or somebody over here that help us get it into the file, but ultimately that's the intent is to get that in that file, the original document, so it is added in for a future reference. And then we would mail that letter that talks about the water right to the applicant.
So they fill this out, give it to you, and then we do what with this?
We review, we take a look at the form, make sure it's filled out correctly and complete. Make sure that we get the money and receive the money. Date stamp the form. Then we would again review the water right. If the water right looks good, we would write a letter saying that we think the water right, looks good. If the water right does not, we would also write that letter.
Water user would normally come here to get their information. So this assumes that they have all the information needed for this.
So we will give them all the information about their water right without this form. This is only if you want comment from our office about the water right, which would be required by DEQ.
Even if they don't have their information, but they want, they need it, they're gonna rely on us.
Yep, which is why we just like to have a fee. If we're having to do the work, and there could be a dead end, I mean, not all these are necessarily. But this is like any other application. There's no guarantee that we're gonna find what's hoped for, but we will do a thorough and professional job. And make good comment on the water, right?
Question.
Yes.
Then what is someone doing right now who needs this input from us to support the DEQ application?
Okay, give you like a hypothetical.
Well, what are they doing right now? Are they just waiting for us?
Yep. Sometimes they call us, hey, they need anything changed.
Yeah, so they're just
waiting.
they're just in a stalemate.
Yeah.
We were getting people coming in
Yeah.
early when we first started this, but after I think they realized it's really was a dollar deal, I think we were trying to have that conversation with DNRC and DEQ to clarify that role, and this is getting to some final stage of defining that role for ourselves.
Yes, sir. And we did jump through a lot of hoops between point A and this form. Including legal review, and meetings with DEQ and
So to Teresa's question, though, you said that we've been helping people. What are we helping them do?
but we help them if we can, if their need isn't to have an existing water right. Commented on. So. Those folks, we're not helping, we can now, oh, well. Should board them, choose to pass, it's for, or get ahead of you. We will be able to address things.
Are you looking for action on this today?
Yeah, I think we should take action, I think. You, ready to speak.
Your thoughts? Is the board ready to take action? Do you have more comments? Public comment? Do we need to change things? Anything I need to change? I'm changing a lot long. That's a minor change, but
Let's see who is,
so am I free to take public comment? All right, take public comment. Anybody in the audience or online has a comment on this water right verification request? DEQ subdivisions.
a lot of times always online.
We should be able to see that. There you go.
Sorry, Mr. Chair, we're having a little technical. Sorry. Maybe it's just nobody logged in. Well, if you're logged in, oh, here we go, participants. All right, we recognize those folks. If you're listening, and you wanted to make public comment, please do raise your hand.
All right. For the public comment, close that at this time. So, take a motion to approve, this form with amendments as we discussed.
I move that we accept the water rights verification request with amendments as we discussed.
Motion by Georgia, second by Teresa. All in favor, say aye. Aye. Any opposed? None.
Thank you, Mr. Chairman.
You got it. You got it. Number 7, IT plan.
All right. Mr. Chairman, board members, recently I've been looking at alternative options for IT services. Our IT services have grown in expense. The original contract was spec'd out at 36 months and was designed with an increase in monthly expense as we brought managed endpoints, meaning computers, into the system. At last check, the expenses were running as high as $2,200 to $2,400 a month. And given the amount of time that we call them and the types of services provided, that seems excessive to us at our office. Brought up some questions. Whether or not we could modify the length of that contract. Whether or not we could find other affordable services that worked out for us. Did meet with one service provider that board had considered earlier. They are also the service provider by our website design. Certainly, in fact, our website design has gone so well, it's a factor. We need to do that. And so met with the first call to get some bids on different IT options. They have both a hourly arrangement and then and an unlimited help desk arrangement. I quickly found myself realizing with some of the projections that I made about how many hours we might use at full staffing, that unlimited is not that much more and seems like a pretty good deal. They have an appeal in that all of their phone numbers are 406 numbers. That's not been the case with Teleconnect. Time zone difference has been a factor. I have created a potential cost savings. Excuse me. And we'll focus put the board's attention here on these two lines where we've got 7 endpoints, which is where we're at currently. For an unlimited fee, this is what the company would charge us, whereas closer to our maximum build out 10 endpoints. This is where we would be. I do have quotes that were sent out. Board members, certainly very thorough, I thought, well put together. The numbers you see to the right here are comparisons on a monthly and then annual basis on what the savings would be if we were able to terminate our current agreement and move over to this other IT company. You see, it's significant. Anyone else? My opinion, that's significant at least. Mr. Chairman, board members, I'm not looking for something else to do, but this is a project that's sort of kind of demanding because here we are at about a year with Kelly Connect and we still haven't managed to get 2-factor authorization up and running. Security wise, we had some pretty rough runs into the low voltage project for this office. Luckily, we got a really good subcontractor and self-managed. The lack of Kelly's showing up. I've requested that they don't inundate us with their ticketing system, and that's going nowhere. That's some issues with Microsoft 365 licensing. It's kind of there's a stack of stuff that for the amount of money it's costing me a lot of time. That said, if the chair would allow, I send a contract over to Mary. She give her 2 cents on it.
Sure. So the limited, detailed review, that I did for this, what I noticed in the contract that was provided, to the board was there is a section for, non-performance contract. It's under 10.2 of the Kelly Connect contract. So that seems to outline what the board could do to essentially terminate the contract and look at other options that might be out there. The only thing is that there are some qualifying pieces, those are just legalese qualifying pieces, so it essentially what needs to happen is there needs to be written notice if that's the board's decision to move forward with terminating this.
Whether we do or not, or have or not, have we written to them with all of our concerns?
We've done it over the phone, not in writing.
So. let's-
Question, and
Yes.
there's no penalty or payment of final fees if we were to switch to a different provider.
So under this section, if we are essentially, if you're trying to be a non-reaching party, then yes, you would just terminate the contract and it would, both parties would part ways. But there are certain qualifiers in their termination clause. So for example, written notice, it has to be done within 30 days of something that would occur. But you know, what that could entail, it could be a written summation of things that have now gotten to this point where the office and the board can't function properly. So it's all in how we want to see.
Thank you.
We don't have that language in front of us, do we?
The
The contract, that particular section of the contract you're referring to,
I'm
can
not
you review that with us?
sure if that was in the packet,
It
but.
wasn't I put up,
Okay.
you say.
On the side, I've noticed that when I've had a technical issue, James has usually helped me out. And he's been great at it, so.
What, let's see.
All right, so we're in the agreement, you're gonna wanna go to 10.2.
Thank you. Sorry for the slow scrolling.
No.
Not sure I can make this bigger in a second. A lot of little things like this. It makes it a little bit hard for me to drive. That must have been on.
Oh, so they have the option to serve such village if we don't do better.
This would only be within 30 days.
Yeah,
Yeah.
yeah. So in absence of written notes, then each following thing, say village.
I haven't asked them if we can terminate our contract yet, by the way. I mean. We're not obligated to not to say no, they could just.
Seems like we should give written notice though, right?
Yeah, depending on too, like, I don't know when you guys started this term, but, at the end of your term as well, you do have the opportunity to use part ways. Without any sort of notice, I just don't know how much longer you have on your term.
The it's almost done. 8/12. A year,
Saturday.
Saturday is a big year. Sweet, erase this.
So what's the term?
3 years, 36 months.
Teresa.
Yes, just my 2 cents. If we're considering termination for non-performance. And if we've had challenges, we should be willing to propose challenges in written form and then engage that process. Seems like we should do written notice.
Right.
Like,
The problem I see with that, I don't disagree with you at all, is that it gives them an opportunity to cure, and then they say, who decides whether it's cured or not?
And that's where I was gonna go, is if they take action to start to cure that. Are we obligated to continue the contract or? Not, or do we still have that option?
yeah.
It would depend, I mean, at that point, that's like where a lot of litigation comes into play too. I mean, that's sometimes when it gets into this, these large contracts like this that are just template-based contracts like this, with boilerplate. You get into those issues of what does a cure mean, and that's where those like civil suits can come in into play, so I understand the concern with that.
We're not behind on. Sure, we're not behind on payments then,
Nope.
so. One of the, in terms of putting it in writing to them, we would. I think, I guess maybe it's a toss-up, would want to be as specific as possible. Item 1. Problem. What we want. Item 2, problem, what we want. Item 3, that way they know what we want. That defines what we believe the cure would be.
An idea is that before going into that level of detail, I'd like to just call and have that discussion and see if we can just verbally explain that we'd like to part ways without going into some big written back and forth. And if they were willing to do that, we don't have an issue, right? I mean, 'cause that could be a first.
Is that an option within the language? If both parties agree, then. we can just-
I haven't reviewed this specific contract for that language, but generally, if both parties amicably consent to terminate the contract, that's fine.
Well, that puts us in a position then to decide if we decide to go that route, then. What's your recommendation?
My recommendation, Mr. Chairman, board members, is that you untie my hands to interact with Kelly Connect to try to, end our contract, first, amicably. And then second, more designated in writing fashion, identifying the shortcomings of the services that were provided, and that if I can get out of that contract, you would also give me permission to engage with, the alternate vendor.
First call?
Yep.
And is first call in a position to provide a better service?
I believe they are. Of course, I might have sat in on this same, comparison without the hindsight that I have now, and, maybe had a picture too. So. I believe that they're better for us, and I certainly, they have, we have side by side. Products from both organizations to compare, because we've got a website.
This first call, they're doing our website. So. Without going too far, have we discussed with them? Option of picking up this work?
Yeah, you have a quote in your packet right there, and I would, furthermore, I'd, rather go with the unlimited help desk option. That's there, because it's a nice buffer in case, that way you board members don't need to worry about calling. You know, we don't need to count hours, and, it quickly, like at about 8 hours, they balance out, 8 hours a month in assistance. I do anticipate 8 hours as well in excess of anything that we're gonna need, but it's a close enough, fee structure where we could have consistency in the budget. Unlimited option.
Are you talking to anybody at CSKT or Wilson IT? I noticed their license.
Yeah, I did talk to somebody at CSKT. You know, there's some good people who work over there. They don't quite have the capacity for what we would be. And
I'm going to bounce back and forth here just a little. So statement on first call, everybody had a chance to look at first call. Any questions on first call? Their bid. So if we agree to take the approach you just recommended, and you call them and they say, no, we don't want to terminate the contract, then what do you propose?
I'll keep trying to work on them with a harder heel on the process.
If they say no, then at that point, I would assume we want to write a letter.
Yep. And we'll be detailed. And
If we get to that, if we got to that point, I would think, even if we don't necessarily need to include it, we would want to see it.
The letter?
Yeah. So that we know what's in it. I mean, if the board. No, so let me ask that question. If we got to the point where we had to write a letter, does the board want to approve the letter or just see it?
Just see it.
See it. Okay. So if we went that route, all right, so where are we at? What do you want to do? Any questions for Ethan? Not, then what do you want to do?
Like to proceed, what you just suggested, let Ethan try to talk his way through it. And if that doesn't work, let him start working on the letter, subject to our review.
Okay,
I think proceeding is good, but I do believe that in the future, these types of discussions should be in executive session, not a public session.
Okay.
I have nothing to add.
are you in favor of moving forward with the recommendation? Okay. As far as it being an executive session or not an executive session, I would say we'd have to talk about that. Because I'm not sure it's required to be an executive session, but I understand. And would be willing to if the board wanted to, so. Would you like to go into an executive session on this now? And if so, I want to hear it.
Just a comment, I think, we began the discussion, specific examples for non-performance in a public way. That's concerning to me. That we did it. That's why I suggest that maybe it should have been done.
When you throw-
Executive.
I get it,
Yeah,
but let me throw this out. It's a public contract. Publicly available, so, and there's currently no litigation involved.
and then if we're, I just view it slightly differently, than if we're willing to talk about non-performance. Then maybe the first letter to post is in regard to non-performance. I don't know, I mean, we publicly in the recording stated that. I don't know, it just is a little bit different to me.
Well, I think the letter would have to explain non-performance and I think the way the language in the contract reads, we would almost have to specify what we think the remedy is for each piece.
It's
Yeah.
just,
That way,
it just,
under the contract, the language says they'd have an opportunity to remedy that. But I think Ethan's suggestion is that we just verbally approach it with them and see if they're willing to jointly with us terminate the contract. If they aren't, then we'll move forward with the next option. So, yeah, I understand. I don't disagree, but that's where I'm at.
yes,
So, all right, so, what's the agenda say? We are at, IT. So with that, are you ready for me to take public comment?
Yes.
Yes. Yes. Teresa, Georgia. Okay, public comment on the recommendation provided by Ethan to approach Kelly Connect verbally first. Should that not work? Pursue it.
excuse me, Mr. Chairman.
Yes,
What did you say? We're going to,
pursue the recommendation
with Kelly Connect.
that Ethan made to contact verbally Kelly Connect,
Okay, that's,
and then if they don't
yes,
agree, then we'll pursue that avenue through a letter.
perfect.
Do I have a motion? Oh, we're taking public comment. I'm sorry.
Mr. Chairman, there's no public comment at this time.
Well, if we're taking action, I'm going to pursue public comment if there is any.
Mr. Chairman, there's no public on the call, and I did check with the one member of the public behind it.
Okay, given that, though, yeah, I understand that piece.
Oh, sorry,
Yeah.
Mr. Chairman. Yes, Mr.
Yeah, no. So, but on the record, you know, we wanted the opportunity for public comment, so that's it.
Absolutely.
There's no public to comment, so no public comment. Board action on the IT recommendation, so motion.
I move that we allow the engineer to approach Kelly Connect verbally. And if that doesn't work out, to the satisfaction of the engineer, to proceed with written notice.
Motion by Ken,
Second.
second by Georgia. All in favor, say aye.
Aye.
Aye. Anybody opposed? Hearing none, approved.
Board.
Thanks for reviewing that language in there with us. right, that puts us to, item number 8.
Mr. Chairman. Given the time and the business that's left, may I suggest the board put off item 8 till a later date? There's nothing really that essential that needs to happen in item 8 that we can't handle either on email or some other format.
Okay. Recommended that we skip item 8 for now. We're good at that. Any questions on it?
No.
All right, let's skip item 8.
Thank you, Mr. Chair. Thank you, board members. Mr. Chairman, board members, when it comes to the time that's left in our day, we are going to try to stick to the 6:30 mark. The items that I would bring up during the close of the public executive session would be the priority that I would have. The items on the personnel policies are important to the office, but I can only, unless the board wants to be here till 7.
Okay, so you want to skip 9?
If the board's excited to leave at 6:30 this week.
Or we'll skip number 9 as well?
Sure.
Yes.
All right. Given our time constraints, as they say on TV, we'll move forward to future action. So that puts us number 10, board member updates. Any updates? Any updates, board members?
No.
No.
So let me bring up one security follow-up.
Mr. Chairman,
Security
that is on the list during the closed executive session.
Okay.
Review the security.
And just a comment and question. So board members, are you caught up on your board compensation submittals? If not, please do that. If you have questions on that, let's make sure we get that done. So those are the only 2 things I had. So with that, public comments before we close the meeting to executive session. Any public comments? Any public online? None?
No,
Nobody
no, Mr.
nobody
Chairman,
going?
there's no
Public comments? All right.
Let's see any hands.
So we have no public to comment. Public comment. 11, next steps meeting August 24. And September 7 are on the list, so tentatively for now, are everybody okay with that?
Yes.
They have staff and service. Nope, I'm good on the things.
And the 7?
I'm good on the side.
Good?
Yep.
So for now, we're good with August 24th and September 7th. So with that, I will take a motion to end the public portion of the meeting.
I make a motion to end the public portion of the meeting.
Motion McKim, by Teresa, all in favor, say aye. Aye, all right. We're closed. I'm gonna go into the executive session. What do we need here?
Thank you, Mr. Chairman. I need the board members or the essential folks for me. You're welcome to stay. It's up to the board.
Yeah, was there something Haley needs? We need Haley for?
Mr. Chairman, I don't think so, but I mean, she's
You're welcome to stay, Haley, if you want.
Things that I don't know about, so.
It says the special litigation matters, so I guess maybe you better be around. I don't know what that is.
No, I mean, if anything, I would just like to set a different executive session between the board and legal counsel. Go over the appellate
Make a
process.
copy and then
So if we could set that today, that would be helpful and I can get out of here.
Okay.
Presentation was great.
Oh,
Locked in or stay
Thank
right?
you.
glad it worked. Hopefully.
Thanks a lot.
Wasn't foolish psycho battle.
And then we compliments.
Yes.
So Haley's asking for a session, a separate session. So do you want to set something now or just have Ethan
Yes.
come up with something and send it to us? Because we've got 2 dates set already. Will one of those dates work?
Do we adjourn the meeting?
Somewhere in here.
Yeah. Let me stop everything, folks.